This courtroom video shows exactly what happens when confidence collides with the law. A self-represented defendant stands before a judge, charged with leaving the scene of an accident, an offense that carries serious consequences, including possible jail time, heavy fines, restitution, and the loss of driving privileges. From the very beginning, the judge makes it clear that this is not a minor matter and warns the defendant about the risks he's taking by choosing to represent himself. But instead of reconsidering, the defendant doubles down. He insists that he understands his rights and believes he can handle the case on his own. The judge responds with a blunt reality check, explaining that defendants who represent themselves are statistically far more likely to be convicted. Still, the warnings fall on deaf ears. As the hearing continues, frustration builds. The defendant repeatedly demands a crash report he claims he cannot obtain, accusing the system of working against him. The judge patiently explains, again and again, that the court is not responsible for providing evidence and that discovery must be requested through the prosecutor. What starts as confusion quickly turns into confrontation. The tension reaches a breaking point when the defendant claims he is being railroaded. At that moment, the judge's patience snaps. With the authority of the courtroom fully on display, the judge delivers a stern reprimand, reminding the defendant that arguing with the court will only make things worse, and that contempt of court is a very real possibility. The video ends with a forceful command for the defendant to leave, bringing the chaotic exchange to an abrupt close. This moment serves as a powerful reminder. The courtroom is not a place for stubborn pride, and representing yourself without understanding the law can turn a bad situation into a far worse one.
Mr. Colton, did you understand all of the rights and plea options I explained to everyone?
For the most part, if I'm not wrong, I am entitled to a crash report, or an accident report, I should say.
Well, if you're not wrong, then you want to plead not guilty today, right?
Yes, sir.
Okay, so, and that can be obtained by you and or your attorney from the law director or the prosecutor's office.
I have asked, I've went to records and it is not available.
Okay, well, we can deal with that later.
Okay.
This is your initial appearance hearing. Did you have any questions about the rights and plea options I explained to you earlier?
No, sir.
Did you receive a copy of this traffic citation that was issued on November 4th, 2020?
Yes, yes, sir.
Okay, you are charged with one count of stopping after, or failing to stop after an accident, or leaving the scene of a crash or accident. A violation of section 335.12A1 of the Conneaut City Ordinances. If you're convicted of this offense, it's first degree misdemeanor. If you're convicted of this offense, you face a maximum 6 months in jail and a maximum fine of $1,000. Do you understand that?
Yes, sir.
Also, if there is anyone who is damaged as a result of your actions and you're convicted of this offense, the court could order restitution, order you to pay restitution to that victim of up to $5,000. Do you understand that as a possible consequence? Finally, if you're convicted of this offense, you face a minimum license suspension of 6 months up to a maximum 3 years. So do you understand that as a possible consequence? And how do you wish to plead to this charge? The court will accept your not guilty plea. Are you asking the court to consider appointing an attorney to represent you?
No, sir.
Okay, will you be retaining an attorney?
No, sir. I'll be representing myself.
That's not a wise thing, Mr. Colton, to represent yourself. You're not an attorney. You don't know the legal processes. So I
do have that right, though, right?
You sure do, sir.
Okay.
So you wish to represent yourself.
Yes, sir.
Do you read and write English for the record?
Yes, sir.
I'm going to provide you a document. It's entitled Waiver of Counsel. Take a few minutes to read it. If you find it acceptable, you can sign and date at the bottom. court finds the defendant has executed in open court the written waiver of counsel document. In this case, Mr. Colton has decided to represent himself, so he will be pro se. Okay, Mr. Colton, I do not have a written bond recommendation from the prosecutor or law director, as this was a citation issued by the police officer, so I have to ask you a few questions. Do you live, the detective has you at 5 West Main?
Yes, sir.
What's the apartment number?
37.
37 in Conneaut. How long have you lived there?
4 years.
4 years? Let's see, Mr. Colton has no prior criminal history in this court. And his last traffic violation was back in 2008. Mr. Colton does not represent to be a flight risk. I will set bond in the amount of $5,000 personal recognizance. And I will set this case for a pre-trial conference in the near future. You're being released on your own recognizance, Mr. Colton. You're going to go, when you leave the courtroom, you're going to go to the clerk's window. They're going to give you a date and time for your next hearing. That will be the only notice you receive from the court, so make sure you put it on your calendar. If you fail to appear for that hearing, I'll revoke your bond and then I'll issue a bench warrant for your arrest, okay? You could also, the city of Conneaut, have $5,000 if you're found, if you aren't here when you're supposed to be here. Do you understand?
Yes.
Do you have any questions for me?
Yes, I do.
Okay, I am not your attorney. I am not your legal advisor. So if you're going to ask me, like you're not the first one who's going to ask me legal questions. I cannot answer your legal question, only procedure. So you have any procedural questions for me?
Yes, I do.
Go ahead.
I would like to know why I am not getting an accident report.
Mr. Colton, you're going to represent yourself. There are what we call rules of discovery. So I would advise you to talk to the prosecutor or law director's office, which is across the hall, and then they'll provide that to you.
Is there a reason you can't?
This is where we get into the situation where a non-lawyer isn't familiar with the procedures. The court doesn't provide discovery. Discovery is exchanged between the parties.
How come the records office will not give me a copy?
Talk to the law director's office. Okay?
Yes, sir.
Get back in here.
Sir, get back in court.
Sit down. What's your problem?
I believe I'm getting railroaded.
You just pled not guilty to a charge. I found you not guilty. I've accepted the not guilty plea. Be quiet! Be quiet! Or I'll hold you in contempt of court. Now, why do you feel railroaded? Because you went to the police department and asked for a copy of the report. You went to the wrong office. And any attorney would know that. You go to the law director's office, which is prosecuting this case. And you don't get it from the court. Any attorney knows that. You might want to reconsider representing yourself, Mr. Colton.
No, sir.
Okay. Do you have any other noises you want to make before you leave this courtroom?
No, thank you.
Then get out of here without making a noise.
This courtroom video opens with a situation that immediately feels tense, even before a single argument is made. A self-represented defendant stands before the judge, charged with leaving the scene of an accident. It's the kind of charge that might sound simple on the surface, but the judge makes it clear early on that the consequences are anything but minor. Jail time is on the table. Significant fines are possible. Restitution could reach thousands of dollars. A mandatory license suspension could completely change the defendant's daily life. The warning is clear, direct, and serious. The judge takes time to explain the risks of self-representation, not in a mocking or dismissive way, but in a manner that suggests experience. He explains that the courtroom follows strict rules, procedures, and timelines that don't bend based on personal beliefs or frustration. He emphasizes that statistically, defendants who represent themselves are far more likely to be convicted. It's not because judges are unfair, but because the legal system is complex, technical, and unforgiving of mistakes. Despite these warnings, the defendant insists on representing himself. He appears confident, almost defiant, believing that knowing his rights is enough to protect him. There's a clear sense that he feels wronged by the system already, even before the case has truly begun. That mindset sets the tone for everything that follows. As the discussion moves forward, confusion begins to surface. The defendant fixates on a crash report, insisting that he has been unable to obtain it. He claims he went to the records office and was turned away. To him, this feels like proof that the system is working against him. He believes that without this report, he cannot properly defend himself, and he expects the court to fix that problem for him. The judge patiently explains how discovery actually works. He clarifies that the court does not collect evidence for either side. It does not act as an investigator. Evidence is exchanged between the prosecution and the defense, and if the defendant wants documents, he must request them directly from the prosecutor's office. This explanation is given clearly, slowly, and more than once. But instead of absorbing the information, the defendant keeps circling back to the same complaint. He repeats that he couldn't get the report. He repeats that he feels blocked. He repeats that this isn't fair. Each time, the judge responds with the same explanation, trying to keep the conversation grounded in procedure rather than emotion. What becomes increasingly obvious is that the defendant isn't just confused, he's frustrated, and that frustration is driving the conversation. He begins to speak over the judge. He interrupts. He argues the point rather than listening to the answer. He seems to believe that persistence will change reality, that repeating the complaint loudly enough will force the court to bend the rules. The judge, meanwhile, grows visibly firmer. His tone changes, not because he wants conflict, but because the defendant is refusing to follow basic courtroom decorum. The judge reminds him that the courtroom is not a place for debate or personal theories. It is a place governed by law, rules, and order. The judge stresses that misunderstanding the process does not mean the process is broken. As the exchange continues, the defendant uses a word that immediately escalates the situation. He says he feels railroaded. That accusation shifts the energy in the room. It implies corruption, bias, and deliberate mistreatment. For a judge, that kind of statement isn't just emotional, it challenges the legitimacy of the court itself. At this point, the judge's patience reaches its limit. He responds sharply, reminding the defendant that accusing the court while refusing to follow procedure is a dangerous path. The judge explains that continued interruptions and refusal to comply could result in contempt of court. That's no longer theoretical. It's a real legal consequence that could add penalties on top of the existing charges. The defendant appears shocked by the response, but still struggles to adjust his behavior. He continues to argue, still focused on the crash report, still convinced that someone else is responsible for fixing his problem. The judge makes it unmistakably clear that the court will not act as the defendant's lawyer. Representing yourself means handling your own filings, requests, and strategy. The authority in the room becomes unmistakable. The judge is no longer explaining, he is directing. He warns the defendant that the hearing cannot continue if disruptions persist. The message is blunt: follow the rules or face consequences. The courtroom operates on order, not emotion, and no one is exempt from that expectation. Eventually, the situation reaches a breaking point. The judge forcefully instructs the defendant to leave, ending the exchange immediately. There is no debate, no negotiation, no final argument. The decision is swift and final, reinforcing the reality that the courtroom is not a place where stubbornness wins. This moment captures something deeper than just a single argument over a document. It highlights the danger of self-representation when paired with misunderstanding and mistrust. It shows how quickly frustration can turn into defiance, and how defiance can escalate into serious legal trouble. The courtroom doesn't respond to feelings, it responds to procedure, compliance, and respect for the process. The video serves as a powerful reminder that believing you are right is not the same as being legally correct. Knowing your rights does not mean you understand the law. And walking into court without preparation, guidance, or a willingness to listen can turn a difficult situation into a disastrous one.